And Ms. Anjali Bharadwaj, over to you with apologies, but please don't cut short your views. Thank you.
Not at all. Thank you, Professor Mohan Gopal. It's a pleasure to be here and a very tough act to follow, Justice Sareen. Very, very insightful comments he's made. And of course, we would like to hear you as well. I'm going to keep my comments short. I'm someone who was involved in the campaign, the public campaign to demand the passage of a strong Lokpal law. And it was a very vibrant campaign, which really galvanized lakhs of people across the country. And I think that at the heart of that outpouring that we saw of people taking to the streets was really this fact that there is a sense amongst a large part of the population that those occupying high offices, high-level functionaries, public functionaries, often are totally unaccountable. They are unaccountable for acts of corruption, for criminal misconduct, for wrongdoing, and which is why we see much of it happening with absolute impunity. So I think it is something that has really troubled people, and time and again we've seen people vent that as well. When there are complaints relating to allegations of corruption that are allowed to languish for long periods of time, no action happens despite, even in the current situation, if you see, so many people have talked about their frustration about large defense deals or other things that have happened, but there are allegations against the highest offices, but nothing seems to come of them in terms of proper inquiry, investigation, leave alone prosecution. So the lack of an independent and empowered body which would look into cases, into allegations of corruption, was something which really has captured public imagination. And there was an understanding that while there are institutions like the CBI, which were very empowered, they were really not probably functioning very independently, and which of course famously the Supreme Court held that they were functioning like a caged parrot. And on the other hand, organizations like the CVC, which at least at the time seemed to be far more independent, were not seeming to be very empowered, recommendatory powers, and not being able to really sort of, bring about that kind of, action which people wanted to see happen. We've also seen, even where in few cases where investigations took place properly, there would not be sanctions for prosecution. So I'm not just talking about corruption, but even if one talks about other kinds of misconduct or, criminal misconduct or wrongdoings, very routinely sanctions are denied. There's no, for prosecution, there is no sanction that is given. I mean, we've even seen in states how, chief ministers have, said that we will not allow sanction for prosecution. I was just looking at, in UP, after Mr. Yogi Adityanath became the chief minister, the then chief secretary told the court that the state's home department had denied permission for the prosecution of the chief minister, allegedly making hate speech during the communal riots in Gorakhpur. So, I mean, these are the kind of things where I think the context in which people are operating, we are seeing, the kind of impunity with which actions are done, especially we've seen for corruption as well. So I think that the demand for an effective anti-corruption ombudsman, whether it's at the state level or at the center, has really been about that independent and empowered body, which looks into cases of big ticket corruption by high-level public functionaries. Now, there is also, we heard Justice Sikri also talking about the balancing, which is very important. I think sometimes what happens is when there is such a strong sentiment, there is also in some senses a tendency to overreach or overcompensate and, in a sense, fall over on the other side. So what we did see was that even during the campaigns that, many of us have been part of, there was a sense at times of people therefore demanding a quick fix, a solution which was like almost like a magic wand, which would quickly fix the problem. And we would, we saw how when the Jan Lokpal was being demanded, it was almost, a demand for an all-powerful, all-encompassing institution, which would in many ways run the danger and the risk of being excessively empowered and could itself become a den of lack of accountability or arbitrariness or even corruption. So it was very important, therefore, the National Campaign for People's Right to Information, which I've been part of, we felt that it was very important to really balance out the kind of powers and the kind, that were given even to the ombudsman when one was formulating these laws. One of the things that, of course, was a point of contention was, whether the executive, judiciary, and legislature, all three should be covered by the Lokpal. And the NCPRI at that time felt that certainly the judiciary should not be covered under the ambit. And, there must be very strong accountability measures, like Justice Sareen also said, for the Lokpal itself that, that should be put in place. There was also a question of whether the Prime Minister should be covered under the ambit of the law. And the suggestion there was that if the Prime Minister, allegations against the Prime Minister were covered, there should be certain safeguards that could be built in, but, not to carte blanche leave out the office, the Prime Minister. So I'm just sort of looking at Section 14 of the Lokpal law, which puts in place some of those safeguards, that the Lokpal shall not inquire into any matter involved in or arising from or connected with any allegation of corruption against the Prime Minister, insofar as it relates to international relations, external or internal security, public order, atomic energy and space, and unless a full bench of the Lokpal, consisting of its chairperson and members, considers the initiation of the inquiry and at least 2/3 of its members approves of such inquiry. So, I mean, we can debate whether these kind of safeguards are appropriate, and adequate, etc. But certainly some of these things were thought of, debated at that time as well. Again, it was very clear that the Lokpal must be given the power to grant sanction for prosecution. And finally, if under the Lokpal Act at that time, if it was found that, any of the Prime Minister, the ministers, or elected representatives, the members of Parliament, where after the conclusion of the investigation, the findings of the Lokpal disclose the commission of an offence under the Prevention of Corruption Act by a public servant, these public servants, then the Lokpal may file a case in the special court and shall send a copy of the report together with its findings to the competent authority. So that's where the Lokpal law, the national law, stands. Now, if we come to the merits or the substantive bits of the Kerala law, which was passed earlier, and of course the amendments that have been brought in right now through the ordinance, I think it's been discussed in detail by Justice Sareen, but the fact that it talks about, the allegation is substantiated, it doesn't talk about really sort of, the guilt has been established in that sense. it does seem like a strong measure. Like I would agree with what Justice Sareen said. It is a fairly unique provision, like you yourself have said in the note, Professor Mohan Gopal. It doesn't seem to be something that finds place in most Lokayukta and Lokpal legislations. And I think that certainly, it does raise some questions it could raise, about various organs of the state playing their roles. So is it, would we then say that let the Lokayukta do its in preliminary inquiry, do its investigation in an independent manner, and should they come up with something that substantiates and the allegations of corruption, then there should be a whole process, and certainly with sanction for prosecution, the power to give sanction for prosecution with being with the Lokayukta, but then perhaps going forward with the judicial, approaching the courts, and the courts, if there is a conviction, then the question of removal. But I want to bring here something which I think, again, is very important from the point of view of the credibility of the process. And there I feel that doing what has been done through the ordinance route and somewhat in haste is something that really, I think, is something that should be avoided. So when we are saying that in many cases, the rationale for a body like the Lokayukta to exist is public trust, where people are feeling that there needs to be this body which is allowed to function independently and is empowered. In that context, when whatever the cause of action might be, but if those who are supposed to be held accountable and for whom it's supposed to function as an institution of oversight decide that they are going to bring in an ordinance and in many ways whittle down or dilute a provision which has existed for a long time in the statute, I think that itself is a cause for alarm. Because, when we are talking about bodies like the Lokayukta, we need to understand that any process has to be done in a manner which is completely democratic. There is public consultation. We keep talking about the need for pre-legislative consultation, and we hope that even if the kind of addresses that we heard from the two justices, I think these are precisely the kind of things that the legislators should be taking into account before any amendment is brought to a law. After all, there are so many Lokayuktas that have been functioning in the country. There is a great deal of rich experience which can be drawn upon. And even if it was felt that a certain provision was too strong or not entirely reasonable, the way it needed to be brought was perhaps had to be very different. And I think the other issue, which it's something that we've also insisted with the central government. Unfortunately, when the Lokpal law was amended and the section 44 of the Lokpal Act was whittled down, which dealt with the declaration and disclosure of assets and liabilities of public functionaries and their spouses and children, it was done within 48 hours without any consultation. And it was something that really eroded trust in the institution itself. Again, the way appointments are made, it's so important that it's done in a manner that upholds public trust in these institutions. I think that what could have happened perhaps was that if there were proper consultations, there's adequate time and given before this kind of a measure was brought in, several other things could have also been brought in as amendments. I mean, I certainly see the point that is being made by Justice Sareen about processing of reports by competent authorities, where, should there be a case where the Lokayukta felt that, somebody is no longer suitable to remain in, to continue in an office, and the competent authority does not comply with those directions, then they're obligated to actually put down their reasons in writing. Now those are the kind of things that could have been debated, discussed, and brought into the law to make it even stronger, like you said, Professor Mohan Gopal, that when you amend, then the hope is that it could actually move towards a much better place. Certain safeguards could have been put in, perhaps, if it was felt that they were necessary. We do know how institutions are subverted. We know that, we would wish that, everyone occupying these positions is like Justice Serene, but that might not always happen for different reasons. So, how appointments are made, how institutions are subverted is known to people. It could be by the executive, it could be by, those in opposition. But it doesn't mean, however, that that the statutory frameworks don't actually hold all those who need to be held accountable. So, certain safeguards could have been built in. I think, again, Justice Serene talked about, whether the Lokayuktas or, should be burdened with the whole process of prosecution. And even at the time of the Lokpal law, at the national level being brought in, there was also a question of whether the same institution should, in fact, do both investigation and prosecution. Should there be that separation that takes place? But certainly sanction for prosecution could be something that needs to be there in legislation like this. It could, the accountability of the Lokayukta is very important. And I think that that's important, again, to build credibility. And finally, the whistleblowers protection that Justice Serene talked about, I think is so important, because very often, I mean, I work, as part of the campaign on the right to information. We've had more than 90 people being killed simply for exposing corruption and filing complaints. Now, a lot of these people, a lot of people we see who don't even come forward to file complaints for this reason, because they know that they will be targeted, they know that they will be, attacked and even killed. So I think that that is very well sort of worth thinking about, how it can be brought into the provisions. The 2014 law on whistleblowers protection that was brought in, unfortunately, by Parliament has not been implemented so far. The rules have not been promulgated for it so far. So nobody is really able to take advantage of it. So if Lokayuktas can sort of, provide, have these provisions, and this law could be there, could accommodate those provisions, I think that would be very useful. So I'll stop here, and thank you very much for having me join here. Thank you.